cool screwdriver kit. Did you guys see this before? Anyway, it flips open, and then you've got these tiny screwdrivers. So, who wants this thing? I don't know. It's got a Shmoo logo on it, and it's got some metal, but I don't know if it's ferrous. So, God, I'm so tempted to just chuck it to the furthest guy. But yeah, I can't do that. I'll try here. There we go. Okay. And the last one, security power tools. This has. Why? Okay, hold on. Wait. Why is this book so popular? I haven't read it. I'm just wondering. Because it's big? I like to travel light, so. This guy's pretty motivated over here. He's running, so come on. Go long. Okay. It looks like I've one more. I hope this is a giveaway and not someone's wardrobe. Actually, this looks pretty cool. I might just keep it. Hold on. Oh, it's an EFF shirt. And it says, this is a good one actually, it says privacy, innovation, free speech. So I'm looking for a 2XL. It's last year's? No wonder they give them to us. 2XL? That's this year's shirt. Okay, you want to give it away? Come up here.
Actually, that was from 2 years ago also.
Oh. Oh. I think if you want current event shirts, you got to buy them up front. Okay. I want to make a quick note about this. The Backtrack guys are having a workshop this evening. I believe it's in this room. It starts at 6:15. Backtrack is a live bootable Linux distro with all kinds of security and hacking tools on it. I think it's a lot of fun, and I think the concept of having a workshop is great, and the guys who make it are here to demo it. And they're specifically showing how to exploit Windows Vista using Backtrack. By bypassing antivirus systems and whatnot. So, sounds like fun. Feel free to come. Okay, I meant to learn something about our other speaker before introducing him, but I didn't, so I'll let him introduce himself. And I apologize for that. As you guys probably figured out, I don't actually know most of these guys speaking this year, so.
Hi, my name is Alex Muntz. I happen to be a lawyer and a geek, so I guess I'm damned from both directions because I get stupid phone calls from a much larger group of people now. And sometimes they're the same person. So it's like, yeah, I'm getting this blinking thing, and oh, by the way, I want to sue somebody. So if anyone's thinking about doing that, go get a dentistry degree or something so you're actually more useful. This is a talk I've been wanting to give for about a year because I've been noticing that lawyers, law enforcement, and legislators look at botnets like they're some new dance craze. IT people ask me questions about, what's going on with this vis-a-vis the law, and I have to say absolutely nothing. They're still stuck in 1984. So this is a talk I gave chunks of this at Hotbots at Usenix last year, and now that I have an entire hour to give a talk as opposed to some poor guy who's trying to tell people that the cyber terrorists are trying to attack your children, I got sandwiched next to him, so I'm like, it's not that scary. Here are the rules you need to know. Okay, some basic disclaimers. I am a lawyer. I'm not your lawyer. This talk is theoretically for educational purposes. I may entertain you, sort of in the Joe Pesci Goodfellas way. Unfortunately, this field of law is changing. It's changing quickly because all we have now are what we like to call bare statutes that may get interpreted in new and interesting ways and change what we think is good law. So, local laws vary. These contents will settle during shipping. I want to thank the Shmoocon organizers, and I also want to thank Jose Nazario because he basically edited a paper I was writing that he basically said, no one does this, we do these now, and I still have it half written that I'm going to publish eventually. Okay, why give a shit about all this? The existing laws to protect end users and computer systems are broad and vague. This is terrifying because broad and vague laws are the idle hands that help the devil, namely prosecutors. If you have these broad, open-ended laws, it's very easy for you to all of a sudden find that what you thought was perfectly legal, that you did for a living, is all of a sudden quite criminal. There's a guy in Boston called Bradley Councilman who found this out the wrong way. He ran a small bookstore, mostly rare texts. He offered email addresses to people that dealt with him. So if you were, Joe's Used Bookstores in upstate Vermont, he just, hey, you don't want to buy an email account. I'll just give it to you if you deal with me. I'm kind of computer savvy. He made one small mistake though. He was filtering through emails to see when people were buying stuff and would often offer them better deals. And while sleazy, up until he got convicted for it, I thought it was perfectly legal. Lots of discretion in prosecution's hands. This is not safe right now. There's a great article by a guy by the name of Paul Ohm, who prosecuted Bradley Councilman, called The Myth of the Superuser. Most laws out in this field are written as if every computer criminal is such the elite hacker, is so brilliant. You read stories about when Kevin Mitnick was in jail and they didn't let him touch a phone lest he launch World War III. Ironically, another instructor in the department I teach in at Temple University was Ed Cummings / Bernie S's probation officer, and they believed that he could hack the computer systems at the prison to let him go if he got the phone. It's like, no one's that good, let alone most people that you're actually going to arrest. But the laws are written as if everyone's that brilliant. Why this is scary to you guys is the criminals are really hard to catch. They do things like cross borders. They don't admit their real names. They don't publish. You guys do. Most of you who, if you're an academic researcher, are quite obvious about, here's who I am, here's how you can contact me in case you want to hire me or hire me as a consultant or transfer to a nicer school that doesn't, it's not snowing all the time. These are, so you as researchers, our mitigators, are really obvious and easy to find because you don't want to live underground. You're like, you want to not be afraid of getting arrested doing your job. So you guys are easily reached compared to those computer criminals. And I like this because I've had these conversations with prosecutors. And it's, some of you, you show up with blue hair, a couple interesting piercings, a T-shirt with an interesting statement written on it that only, 1/10 of 1% will find funny. And the difference between that as, hey, dude, like I hack Linux and I set up firewalls and I smoke a lot of weed, but I'm not a real criminal. The difference between that guy and elite hacker cyber terrorist in a prosecutor's eyes is not one bit, because they're going to paint you as one and the same if you do something wrong. And, while we see the difference, they won't. I want to give one, FUD alert, because I hate every talk that sells itself as, the hidden threat to you and your users. And it's like Action News always does at 6 o'clock, the teaser for 11, the 10 hidden deadly threats in your house to your children. And you're like, oh, I got to watch that. And things like, Drano is awfully dangerous if you drink it. Like, well, thanks. Wasn't planning on that. Spoons, the hidden threat to your child if you jam them in their eyes. It's like, but it's this like, oh shit, something scary I should learn about. And the problem is, in the field of technology, to most end users, you can't tell if I'm lying or not. Hey, that new cyber virus worm thing caused your computer to spontaneously explode, killing everyone in the house. I'm sure most of your end users, you could convince that. If you just kept it kept your face straight for 5 minutes. And they'll be paranoid because they'll believe it. I could tell you about new laws out there that, you have to, not only can you not, you have to send your root passwords to some office in DC, but when you log in, you're not allowed to wear pants. And I'm sure there were some people going, I can't tell if he was joking or not, but I'm not taking the risk because I don't want to, get a felony on me. So a lot of this stuff is theoretical. There haven't been, when there has been an effective prosecution or even someone getting indicted, I'll let you know. But right now, these are theoretical risks out there. Okay. Yeah.
The question that I had was, so in the sense of meteors is, FUD type stuff. But one thing, I'm a very theoretical person.
Okay.
But what I'm told is that, my education level in terms of computers and computer security is such that if someone were to compromise my machine and add it to a botnet, I would have no defense whatsoever.
Well, it's not criminal for you to have your machine compromised. Right? I mean, well, actually, it isn't. Because it's like it's not a crime to have your car stolen. It's annoying, but you didn't do anything wrong. So you don't have to worry about that so much. You do have to worry about your role as either a researcher or your role as an IT defender, because there are certain things that you may run afoul of existing federal laws. So I'm going to start with the Wiretap Act, 18 U.S.C. 2511, for those who want to look it up. Regulates the uses of wiretaps. It's the last time it was amended, I believe, was USA Patriot. It regulates the use of wiretaps, sniffers, and full content network monitoring. It doesn't say that specifically. It just says anything that collects content of electronic communications, broad as hell. Talking to a few other computer-savvy lawyers and prosecutors, it's most likely sniffers, IDSs are implicated. Anything that is capturing more than just packet headers on a network is regulated by this law. Divulging information illegally captured via this is also a crime. Very broad prohibition against it. Now, interception is defined under this law as it has to be contemporaneous with the transmission. It's the acquisition of the contents. So this is doesn't have to necessarily be human readable, but it has to be something more than what you had to give to other people to route the packet. There's this ancient case dating back to like 1870 about you have no privacy rights in the outside of an envelope because you, by their very nature, had to give it to someone else. They had to read it in order to get it to the eventual place. There are some cases that say you have no privacy rights in the packet header because you had to give it to somebody else for the packet to get there. You can't, it's kind of hard to route an IP packet. It's like, what's its destination? It's a secret. Where's it going? It's like... So it criminalizes, though, the distribution of illegally obtained communications, which will grow to bite us in the ass a little bit later in this presentation. If you illegally take stuff and hand it off to somebody else, so you can't do the whole, this is one of those fun word games I often have at hacker conferences where people say, like, if I don't do anything but someone inadvertently gives me a bunch of wares, it's like, that's still not a defense. You know it's illegal. Now, there are some exceptions that let you capture packets, obviously. One is a valid wiretap warrant or a FISA order, or if you're currently in the administration. And we won't go into that because all you'll have is, be Alex's 45 minutes of just ranting profanity with maybe vowels. That'll be performance art. Prior permission.
Wasn't it just renewed too?
It expired, I think. But don't worry. Don't worry. You will be protected. We'll pass it. Okay. Another exception is a prior permission. Prior permission. You can't get it retroactively. Of one of the parties to the communication. It does not have to be an active party. Yeah.
But how about in the states that require you?
Thank you for skipping ahead. I'll touch on that. We'll bring that up if I don't cover it in about 3 slides.
What about Google's content network?
There's a permission somewhere. somewhere. You don't have to actively, you don't have to sign off an affidavit to somebody to say, you may sniff my packets. Think of, there's about 3 or 4 important cases in contract law when it comes to contracts on the internet. You've got, originally you had the shrink wrap. By opening this CD, by breaking this package, you agreed to the 97 pages of clearly written contract that I remember when I went to law school and I was still working in IT, it took me hours to install software because I actually read them now. And I remember doing that. It's like, okay, I need you to set up these 5 machines. 8 hours later, it's like, what have you done? Got Acrobat on this one, and I'm still installing Windows here. And it's like, what? I'm like, oh, and I've got like 12 pages of notes on the, it's like, I can't now. He's like, I'll give it to someone else, asshole. I'm like, okay, sorry. Yes, that's why I'm a lawyer now. And now I've decided, like, I don't know what they mean either. So I just click right through. So you can permit someone to sniff your packets by now browsing their site. There's browse wrap contracts, which are, if in the lower corner of a web page, terms of service. By using this web page, going past the index page, you agree to these terms. So 4 years later, hi, we're here for your liver. And you're like, what? Like, remember when you were looking at hotbabes.com? Yeah. Like, you click, you continued browsing after we let you know that we got your liver. Check them. They're terrifying sometimes. Because what scared me was after reading some of these, then talking to lawyers who wrote them, they're saying, I don't read them. Like, dude, you charge a client 28 grand. It's like, yeah, I cut and paste them from other ones that I liked. It's like, wait a minute, you don't read them, you write them! Jeez! Yes, he says, yeah, it's like, and they're sometimes contradictory. I'm like, how does one conflict with 4? And then, like, what's this other company? Like, oh, I didn't proof that. Like,
That's why only I've charged is $28,000.
yeah, it amazed me. Like, and you bill $7.50 an hour for being an internet lawyer? Wow, I'm in the wrong business. Okay. The other 2 are these weird little rules. You can sniff packets or you can capture the content to identify the source of an electronic interference. It's only to identify the source. It seems to be a weird holdover from radio, but when they passed the Electronic Communications Privacy Act, they changed everything to end electronic communications. So there's stuff about, like, the FCC partially regulates this, and there's stuff about how, they still talk about trap and trace devices, which I think have just been built into phone switches for years. But it's still there. They haven't changed it. So there are a lot of people who are going to build arguments based on this is like this and this is like this. And I hope to God for any of my clients that a judge goes, uh-huh. Otherwise, we're all doomed. And the last one is what they call the provider exception. Provider is not necessarily someone who provides the service for a fee. You run IT at a 75-person company. You've got a LAN. You are a provider vis-a-vis your 75 users because you provide them a service, a telecommunication service. You hook them up to a router. That's the service. You don't have to charge them. Yeah.
But if there isn't, say, a web server on that LAN that services the outside world, are you a provider of services?
Yeah.
In
Yeah.
the context of that law for the web service?
Yes. Once you are offering something out there that other people are using, it's now a service. It's a very, very broad rule, which is nice because it's also it grants you a lot of rights to sniff packets. If it's to render the necessary service, because you're also looking at the content. Like, if you think of it as, I need to route this packet, I have to look at chunks of it to send it. For phone stuff, back in the day when you actually did manual routing of phones, you called an operator, they had to listen in for a minute to make sure the connection went. So they were capturing content. We've left that part of the law in. You may also sniff to protect the rights or property of the provider, but all the cases I've read on this are about the fraud to the provider to steal from the provider the justifiable charge they were going to get. So think blue box detector rather than Vinny and Joey are committing insurance fraud. They both pay their phone bill. The phone company can't say, well, I'm protecting someone from fraud. Like, you weren't protecting yourself from fraud. Vinny was paying his phone bill. Nothing good there. You can't listen in. And there's the prohibition on distribution if you have no knowledge that the content. So I, nefarious bastard that I am, sniff packets. I give them to one of you, saying I had permission. And trust me, I'm a lawyer. I wouldn't lie, deceive anybody. So therefore, you taking it, even though it's illegal, you go, I trusted him. Yeah, I know I fucked up, but I trusted him. So now, of course, if I say, yeah, I got them legally, wink, wink, like, wait a minute, you should know now. Trap and trace is much more limited stuff. It's basically routing information. It steps back to who did you call, when did you call, how long was the call, who called you, how long was it. It's more permissive, though, for a provider because you have to do it for billing. You may also do it to protect from fraud. I mention this because less than full content packet sniffing is covered by this. And there's the provider exceptions wider. You can also use it to protect networks that you connect to from fraud or abuse. So it's a wider rule. Stored Communications Act. I will. I forgot that's a couple slides down because I talk about federal then state. 18 U.S.C. 2701, this protects electronic communications while in transitory or long-term storage. There are cases that make this very strange, that storage, no matter how short, and they give the example of while in the memory buffer of a router is in storage, and therefore it's not covered by the interception law. But it's not really storage. No one retrieves it from the router unless you're doing something very strange that I want to learn about. Now, it's very broad for providers. An owner of a system may pull data that's stored, even for an infinitesimal amount of time, for any reason. It's okay. So you are AOL. They can read your mail under this law and not violate it because they own the system. If they intercept it, if they grab it while it's on the wire, while it's being transmitted to you or from you, that's different. That goes back to the Wiretap Act, and they have to have a much better reason. They have to be doing it to protect their own systems. But if it's in storage, they decided to read it. Why? I was bored. Good enough. 1030 is the old Computer Fraud and Abuse Act. This is the act that got Robert Tappan Morris for the Morris worm. It protects pretty much from intentional unauthorized access or exceeding granted access. I give you I give you a regular shell account on my Unix box. You root it. You've run afoul of it. Even though I granted you permission to be on the box, I didn't give you root. This is actually almost irrelevant. I'm going to skip to that. State laws. Okay. Most states have laws that parallel the federal ones. Some, in fact, use identical wording. However, and this is where I'm going to get to wiretap law. Federal wiretap law requires what's called one-party consent. Two people are I'm sending someone else an email. Either of us, under the federal law, can consent to someone in the middle sniffing it. Some states, Pennsylvania, for example, requires all parties to the communication to consent. There is a very small, very weird exception that says if you have prior permission from one of the users and said permission has been reviewed by the Attorney General, and it is in writing, then one party may consent. And it's like 19 sections that I find like, that's not an exception. That's like a one-time deal. Now, other stuff that's going to come into effect if you are a researcher are the common law torts of nuisance, which is I may not operate my property in such a way that affects you. Yeah?
So how does the single party consent law work across, in interstate? Visits my webpage that posted in Virginia, and my webpage captures all their information.
That is a problem of jurisdiction and choice of law. And I could lecture about that for about half an hour. Yeah, I'm almost out of beer, so I probably won't. Generally, the federal law then supersedes and says one party is good enough. Generally. I can be coerced into talking more about it.
I have scotch.
Yeah, then I'll talk about FISA. Okay. Slander and libel. I brought this up because I've read there are actually cases about this. It's actually good law. Where people have said, I am a security researcher. I think your product is spyware. And instead of someone going, oh, shucks, it's, fuck you, I'm suing. You have libeled my product. You have taken my stupid little thing that does in the corner and does cute, amusing things and also sniffs all your packets and called that spyware. How dare you? People like the Bonzi Buddy. There's a suit about that. It's like, wow, someone sued about this. Like, that's cyber law. Wow, because we have so few precedents to deal with. It's like I can read like 20 cases and go, I'm an expert in this field, which is why I picked it. Like a friend of mine always talked about doing I'm going to be a Third Amendment scholar. There have been no cases on it ever. Just I read it, yep, I'm going to lecture about it. That's the third. Can't have soldiers in your house. Thank you much, I'm done. Pay me. And intrusion into seclusion, which is this, you have a theoretical right of privacy. It's a civil law. It's you do this to me, I get to sue you for money. This may be relevant later. Okay, so let's actually talk about technology. Botnet research. First, you capture little bastards. You can actively do it. You go out, get it. Either use your vulnerable app that tends to collect the bot and go out and surf. You can simulate it. You have some tool that does it, so you don't have to have a graduate student or an undergraduate go out and look at porn sites. At least that's what I've been told they do. I've never done it. Or FTP. There's a malware repository over here. I'm going to get it all. Or passive. Set up a honeynet, set up a honeypot, or you collect it from your end users. Hey, heard you got an infection. Do you mind if I take all that, after I clean it up? Symantec might be interested in it. Okay, how can this bite you in the ass? I thought about this because I actually got a couple of emails after a talk I gave about 2 years ago, someone who had built a misconfigured acquisition tool to go get spyware, and it instead somehow tripped off a really messed up script on this guy's page that had him sending hundreds of SMSs to all the contractors at this guy's construction company in Scotland. And he traces it back to my guy, and it's, what you doing? I'm spending hundreds of quid for SMSs because it was just tripping the script. And it's like, dude, how did your tool pick that up? It's like, I have no idea, but am I liable? And I said no, and he paid him anyway. I'm like, oh, okay, But the thought was, this could be a problem. You misconfigure the tool, it goes out and crashes an innocent person's computer. I thought this is a theoretical problem, but we have a problem. This guy wrote the tool and it broke someone else's stuff. Even if that other guy's stuff was messed up. You have the magically misconfigured computer that if it gets a ping on this port, it just shuts down. It's not their fault that they've misconfigured it. It's your fault for acting in such a way that damages their thing.
So
Yes. So if you intentionally write it in such a way that it messes up stuff, it's a federal criminal violation. If it's you just, I spaced, I didn't know about that vulnerability, oops, sorry, you might be theoretically, and this is theoretically liable for the tort of nuisance for your stuff breaking their stuff. Hasn't happened yet, but it doesn't mean it won't. Downloading from a malware repository. If it's in violation of the site terms of service, and you may either violate contract law where you'd have to pay them. You may only download if you pay me, and you go, you're a fucking hacker. Sorry, not hacker. You aren't leak criminal dude from Romania. No, I am not paying you for your malware. They may sue you because what's an illegal site? It isn't a term yet. It may be perfectly legitimate there. Okay. Passive capture, setting up stuff. This is kind of because this is a bigger method of doing stuff. It's a possible nuisance. I thought about this. If you have a honeynet that is so configured that it's actually taken over and used to exploit other people's systems. You're like, hey, we're researching. Hey, wait a minute, we're part of the biggest botnet out there. Good job. You're theoretically liable for that because it's like, hey, I've built a swimming pool in my backyard. Hey, I haven't maintained it for 2 years. Hey, West Nile is up 38% in my neighborhood. Oh, I've operated my property in such a way that it's affected other people. If you set up if you set up a network of boxes that's allowed to be exploited by another party to go and trash third parties, it's your fault. You're liable. Civilly, not criminally. Yeah.
Well, there has to be some kind of line there about, because obviously a user who misconfigures their computer by not applying the appropriate patches
is also a nuisance.
Right. So obviously there must be some kind of intent, or maybe there's just no written, it's just purely
this is theoretical. So it may bite us in the ass at some future date. Because when I researched this, there are about 85 law review articles, and law review articles are the worst theoretical masturbation I've ever read, because it's like, there's a case about where two couples both get in vitro fertilization at the same clinic, and they go, oops, and so each is raising the other family's kid. Been 2 cases about that. One in California, one in New Jersey. I think there's another one in Britain. There are about 270 law review articles about the clear understanding. Like, who cares? This is a big enough problem, but every legal academic has to write about this. So the whole nuisance as potential claim, lots of lawyers are talking about that don't practice. Yeah.
So, if you misconfigure your machine that is used to attack some other systems, has negligence ever been brought to say you're negligent of yourself?
That's the argument. That's why I'm saying it's theoretical. It's a potential threat out there. There's also, I wrote an article saying it's not so much the user, it should be the OEM of whatever vulnerable tool, because they had better control over it. Microsoft knows more about their security vulnerabilities than my mother.
So you're saying it's going to shift the route of non-security on is the liability to the manufacturer?
I'd argue that if it's used to attack other people, I think put some more burden on them. I did this big long cost shifting analysis that you don't have enough drugs for me to go into today.
What about Google's search bot going out and finding vulnerabilities in the machine and posting it out to their website, and then Google hackers taking full advantage of that?
Well, interesting. So they're finding vulns on your box and publish it. So it's like being at DEF CON all the time. Okay. Let me think on that. Collar me after the talk. I haven't heard about that. Okay. End user collection. If you do it without permission, you are violating a shitload of laws, potentially, because you are accessing their box without their permission to get something from them, even if it's dangerous. even if it's fucking up their stuff, because it's all about permission. Now, of course, if you're collecting stuff, you're either one of two things. You're either Symantec and you have your spyware designed to phone home to say, I found something new, it might be interesting, we might want to upload it. So in that 18-page document that you clicked on or really ignored when you said, I agree, you just write a clause in there. Or you're a security researcher, you email or somehow contact someone who's attacking you, find out it's my mother with a machine infected with spyware, and you say, hi, I'm a security researcher. In exchange for fixing your box, I'd like to download some stuff that you don't care about, and you get it. So permission is not that difficult in the real world. Okay, testing of the malware. Reverse engineering static analysis, and this is something that came to me about 2 in the morning. Is it potentially copyrightable? Is malware protected? And I called up 2 friends of mine that do copyright law, and I think the response was, shut up, like, please, I don't care. And I kicked around with another geek friend of mine, and he was like, I have no idea. So it's a thought. I don't think it is, because you generally can't copyright things that are pernicious. But
Pernicious is all in your attitude. Whether it's your remote control
Disagreements of a lot of those kind of programs, specifically disallow reverse.
But actually, one, you can't specifically disallow reverse engineering. It's a right under any contract, under patent law. Also, you generally don't agree justifiably to spyware, because they don't get, hi, I'm installing spyware in your system. Okay, I disagree. Huh. Most users, but instead they sell it as something else. There's some case that says that contract is null and void because you were deceived. Also, hi, I'm a Bulgarian botnet herder. I'm going to sue you for disassembling my tool. No, not happening. This is like ultra theoretical. It's one of those things that wakes me up at 3 in the morning and go, wow, I can't go back to bed. I have to go look this up. Because none of us have ever experienced that before. Like, oh, wait a minute. Whoa. Sandbox.
How about the case recently where somebody was just using NS lookup to go out and do IP address, the host name conversions to find host names used by, I believe it was a spammer or a pornographer, so that they could add them to a block list, and he successfully sued them for...
It would be libel or slander. Would be one claim, because it's saying you say my company is hosting spam. Okay, because it's an improper use.
But you have a name server out there whose purpose is to convert IP addresses to host names and vice versa. And his argument was, well, I didn't intend it for somebody to go out and look up host
Yes.
names that I didn't want people to know about, despite the fact I published it to the whole world.
He forgot to disable zone transfers. And that argument with the prosecution was he was using it in a manner that the normal person wouldn't use it. He was going a little bit above and beyond.
Yeah.
I mean, bullshit argument.
But there are cases that say, even though, like, I have a web server, which theoretically, if you think about it, it's world readable, but you're not allowed to use it. I put on the site, Eric Hacker, my friend from college, is not allowed to use it. He uses it anyway, saying, it's a web server. Because there are claims of, like, you weren't allowed to use my web server in this way, and I put it in the terms of service. It's good. Yeah, in the back. That, God, I thought that was, like, forgotten about. They're going to cover it by contract. You agreed to this somewhere.
Would be the copyright because you're using the music?
No, because just because you're using the music, there's this whole first sale doctrine, and that's another 20 minutes of intellectual property that I try to forget about. They're going to argue somewhere that you permitted them to do that. Because you clicked on something, I think, to install it. And I don't remember, because I did not at that time have a Windows box, so I couldn't actually go and find a copy to install it. to see like what is, because I got 90 questions about that. Like, hey, can you write an article about this? Like, I don't know what you're talking about. Like, I saw it on Slashdot, but I haven't seen it because I want to see the contract. Like, the one thing that will make it go from shitty but legal to, oh, this is going to be fun.
The contract does mention it that it's going to install a specialty alarm on your computer.
Okay.
It does not say that it's going to put rootkits. ESF successfully got a class action lawsuit that anyone that did purchase it would get a refund and a free MP3 download as a result.
Sweet.
So can you put on your website that in your terms of service that your competitors are not allowed to access your website?
Yep. There have been 1030 cases about competing. There's one, it's competing travel agencies. One uses a web scraper to automatically pull pricing for trips, so the other one can underprice them. That seems a fair competition to me. And they turn around and sue based on it's not permitted. We have in our terms of service that you may only use this if you are considering buying travel stuff, tickets, pricing, whatnot. You weren't going to buy any of my tickets because you're a competing travel agency. And they settled it out of court, but it was not kicked out under summary judgment. So there may be some action there to say, I exclusively don't permit you. Now, there may be some line that a court will draw to say you're being ridiculous. GM can't say Ford employees may not look at our site. Yeah, in the back. No. Thank you. Please try again. Nope. Oh, can you put in your terms of service, law enforcement can't come in? You can also put a sign on your door saying, law enforcement, you're not allowed to enter here. They'll enter. But nice, yeah, it's one of those like you can't know. Because if they're coming in for a valid reason or an investigatory reason, they're allowed in. There's one, and I'll divert for a second, there's one, Conop v. Hawaiian Airlines, where a pilot who was very annoyed at the management of the airline he worked for put up a site that was basically like, come in here and bitch about management. However, he was a moron when he set it up. Instead of saying, email me for a login, because I'm going to put it behind password, a little bit of security, he instead set up every user. He had a pilot list. So he set up every user, and all you had to do was type your name. The president also happened to have a list of the names of pilots and just started typing them in. Eventually found one that had set with the default password and said, oh, I get to look at what you're all complaining about. Go up to the guy who's running and go, you're fired because you're running this site. How do you know? I looked at it. And the guy sues for like you violated the law, you violated 1030, you violated 2511. And the court basically said, even though it was password protected, even though you had in your terms of service you weren't allowed to come in, yeah, you didn't really secure it that well. And it's kind of a muddled decision, which unfortunately it's also followed by about 38 other decisions, so that muddled is what our law is. Going back to malware, running a sandbox. It's back to a potential nuisance if it gets out into the outside world. Thank you. Legal issues of publication. Libel and slander if you make a negative, untrue statement averring fact. Your software is spyware. No, it's Microsoft Office. Trade secret. If the vendor has disclosed controlled secrets under contract or under some method of protection to you, you go divulge them. And then there's the 2511. If you've illegally obtained it, you can't say it again. Okay, monitoring of those herders. Logging onto an IRC server to get information, either passive or active. Sniffing traffic between the bot and control channel, and what if the herder's using a mixed server, i.e. an IRC server that is both doing legitimate IRC traffic and also used to control bots. So finding out what's illegal traffic is difficult. Those people who are running legitimate traffic can come to you and sue you, or can come to you and go to the prosecutors and say, these guys are sniffing my traffic. Okay, so I'm going to go through a couple scenarios here. We have an infected machine, we have an IRC server, we have a herder. The infected machine comes in and says hi. The herder controls it through the IRC channel. We have a researcher. Researcher comes in here and sniffs the traffic. It implicates 2511. The researcher is actually going to be violating 2511 because unless the researcher is either the IRC runs the IRC server, the network that it runs on, or the herders, he has no standing. Say instead he logs into the IRC server, he may be violating 1030. He may also be coming into 2701 if he's pulling data off of it, pulling stored communications off of it. If he's sniffing there, we're also going back to 2511. So we have two new people, neutral 1 and neutral 2. They're uninfected boxes just out there being used. What if they're using the IRC server? So their traffic is going between them and the IRC server. The researcher comes in and sniffs stuff. That violates 2511.
Even if the researcher owns neutral 1 and neutral 2?
If he owns any of those boxes, then 2511 is not implicated, and he's okay. Yeah, then it wouldn't be neutral. I'm assuming neutral 1 and neutral 2 are two completely unrelated users. If you get authorization. I'm assuming that none of these parties know one another yet.
But if the IRC room was international, wouldn't the protected computer provisions of 1030 come into play?
If it doesn't even have to be international. It can be just pretty much any box on the internet involves communication is likely to be protected under 1030. I saw you with your hand up first. This is theoretical. Other than what I just last said, that if it implicates, because it's crossing state lines, pretty much anything on the internet, even if it stays intrastate, is likely to raise federal questions and raise 1030 issues. Yeah.
With the communication law, if you were to actually contact the ISP of neutral 1 and got their permission, would that be acceptable or is that still not?
Interesting question. Now, the ISP of neutral 1 may have the right to do it from their contract with neutral 1. The question is, can they then hand the right off to the researcher? Potentially. It depends on the contract. It also depends on what the researcher is telling the ISP. It's, hi, I'm a researcher, I want to sniff this stuff. And the ISP knowingly says, yes.
It's got to happen the fact, though, since they're already doing the research and know the ISP.
Right. You may have, it may be in the terms of service though, between the ISP and the user. So researcher sniffs, that may violate 2511 unless we have that agreement. Now the infected machine goes after the researcher's box. Either it's a bot, either they're running a honeynet, or it's just there. Researcher can copy stuff. Yeah.
What about the distinction between an infected system logging into the IRC server and a researcher logging into the IRC server if you're mimicking the behavior of the
Okay, so we're spoofing, you're saying we're spoofing an infected box. And the researcher is logging everything. It may implicate 1030 because you're accessing a machine that you may or may not have legitimate access to. If you're using some kind of password that you got from spoofing the infected box, you may be actually violating that and 1029 because it's an access device. Now, realize though, if it's actually infected, you really you're not likely going to have someone come forward and complain. If a crime occurs in the forest and the only people who hear it are criminals, it's not going to come up because the bot herder is not going to go to the feds and say, yeah, I was running 100,000 bots, and this researcher from Carnegie Mellon came in and they logged into my IRC server. They're going to somehow do a proportionality test and go, could you stand over here for a while and wear these for a while and hang out for a while and tell us more about this botnet you're running? What you're really afraid, though, is capturing innocent stuff, is inadvertently grabbing the neutral parties.
stopping the botnet herder from perhaps inserting fake innocent parties to pick you off their tail?
Ooh. Yes, that is a fear. Because you can't know until you sniff packets if it's, this looks like control channel stuff versus, oh my God, did you see that? You know, the typical IRC chatter. You don't know. They may, in fact, insert innocent-looking IRC chatter, so you can't tell. It's like the old mobster movies where a wiretap could only go on for a few minutes because they have to limit it. They would have innocent chatter go on for 10 minutes until they realize we have to turn the wiretap off. There is nothing relevant to our criminal investigation. Turn it off. IRC herders looking at this may decide to start throwing in chatter. I'm kind of running out of time. I'm going to skip to defenders. Okay. You are no longer a researcher. You are just trying to protect your boxen or your network from them. Passive networking stuff, passive monitoring stuff. You have an IDS on your network, on a client's network. If you have it on client's network or you're monitoring, you want permission from the client. The client wants to have permission from the users, and you, as Joe or Jane security person, want to have in your job description, my job is to sniff packets. That way, everybody is protected. You need a chain of stuff that your company is allowed to sniff packets. You, as a part of your job description, is to sniff the client's packets. So that way, no one can come in and say, you are an unauthorized access to our packets. Server-side stuff. What happens if you find that your machine is compromised? It's not just a bot, it's running a server. You can do a live or static investigation. Generally, because it's yours, you have access to all the stored information on it. It's yours. Okay, I want to talk a little bit about more active forms of defense. Takedown disruption. You can pull the plug if it's yours. You can null route it. It's okay if you have permission or it's yours. Actual permission, or you can do constructive permission. You can have in your terms of service, if you are an ISP, your machine's infected with a bot, I get to cut it off. I don't have to call you. Just have it as a clause. You're good. DNS poisoning. It's a contract between whoever has been poisoned and the DNS provider. I think you're okay as long as it's a clause in there. We like to look at this because, you talk to vendors and they talk about, I remember this was like a big macho counterattack thing a couple years ago. Shutting, not only does our botnet defense tool, protect yours, it takes out the bot. And that is probably going to be illegal if you inadvertently shoot somebody else with that tool. There's all these, I'm trying to remember who came up with it at DEF CON about self-defense arguments, and it's like, yeah, you know what, that's what we call an affirmative defense, which means we don't know if it worked until you're at trial. Not exactly where you want to be. Like, man, I thought you said this was going to work. You're like, yeah, I thought it would. Sorry. Okay. I have a theoretical. I think we've already covered that. Okay. Ending stuff. To protect yourself, write a monitoring clause in all your contracts that you have to do it. Seek to avoid monitoring innocent traffic. How is left to the reader. Routing metadata, less protected than the content of communication, so feel more free to grab header information. Stored communications are protected differently and less, so doing forensic collections on machines is generally safer than actively attacking those, sniffing your network. Of course, that is very much a, closed barn doors after horse has left problem. Like, oh, what happened? Well, we got owned versus we could prevent being owned. Counterattacks are just stupid. They're likely to increase your liability rather than decrease it. Feel free to email me if you have any more questions. I'll also answer questions outside. How are we on time? Oh, wow. Oh, okay. Okay. Okay, any questions? Yeah.
Have you experienced that there are any better federal or state jurisdictions in terms of giving, the judges giving sane opinions?
No. Realize that, no, it's not that they're insane versus sane. There's so few that have seen this. And I hate to say it, but the reason why most people go to law school is because they sucked at math. I read an opinion coming down here that talked about using a snifter to acquire data. And I thought, oh, it's just a typo. It wasn't. It's repeated. It's like, oh my God. And there's these, the bigger thing, and you'll, if you see John Benson's discussion tomorrow about electronic discovery, which is what I used to do for a living, until the brain damage finally took its toll, there are opinions that make absolutely no sense because judges have to figure this out, and they're not good at it yet. Yeah, you all the way back.
Don't blame the snifter on incompetence on the judge's part. It could more easily be blamed on Microsoft Word, all the correct.
But think of it this way, it's kind of core to, like when you're writing a technical article or writing a technical letter, when it highlights I think this word is misspelled, you still go, no, that's what I meant, learn it. I thought about that, but you check that, because it's kind of like, oh, that seems to be a term of art. That seems to be important. Yeah.
I think it's safe to say the judges don't get it. They're not going to get it in the near future. Hopefully we'll get some law clerks in there that do get it.
Judge Kaczynski gets it, but Kaczynski is a judge in the Ninth Circuit, which is basically like the west half of the country. He, however, caused my ex-employer a ration of shit because he viewed that any network monitoring was bad. And he went in and actually actively disconnected it. He walked in himself. I worked for basically the IT department of another circuit, the Third Circuit, and we had to write a white paper to say, Judge Kaczynski, we know that you have some opinions about this. As IT professionals and lawyers, we need to do some kind of monitoring to protect the network, because you have valuable stuff. Like, wouldn't it be nice to know how an antitrust case gets handled before Wall Street does? Yeah.
You've been seeing a lot of news lately about, and this has to do with electronic discovery, about people finding pictures on the social network, MySpace,
Yeah.
Facebook, and then I read about this specific case where some kids were at a party and they were drinking, or at least they were holding beer bottles, and the school had repercussions where they suspended these students, they put them on leave from their sports programs and stuff like that. I mean, how does that really? I mean, is that strictly to deal with how the school system works,
I mean, it's evidence. It's proof of something that happened, and because digital evidence is both it's leakier, and people forget that they have it. I can think of the amount of cases I've read of, hi, my machine's broken. I take it to the repair guy. Repair guy opens up and goes, huh, that's a lot of child porn you got there, Bob. There are numerous cases like that. So the digital data or digital evidence is and people find it. And with Google and the social network stuff and the fact that people are now knowing to look for it.
What about in cases where something may be illegal in one country and not in another?
Where are you at that time?
How can you prove where the picture was taken?
No, it does. I mean, How many cameras have GPS units in them? Really? Oh shit! I don't know, because I'm always, I look for the less features when I buy stuff because I don't want that one thing to break and break everything else. It's like, I finally broke down and have a camera phone. For the longest time I go and beg, do you have phones that don't have cameras? Why? Because the guards take them every time I go into court. Because they do. It's like, oh, you can't bring a camera phone in here. I'm like, I'm a lawyer. I go to court. Like, how often do you go to court? Daily. Oh, man, you got a problem. Like, no, I'm supposed to go there. But it's like, I need it. And I'm thinking, can I just, cut it out? And I'm not that good at electronics, so I'm afraid that I would completely break the phone. Yeah.
About
2511 interception.
But it gives me the credentials to get onto the server. In other words, it says, you're infected, go to this FTP server, use these credentials to go there and drop off your stuff. I'm a researcher. My machine's infected. They've given me the credentials to do that. Why can't
Well, no. They gave the bot credentials to do that.
So you're saying as long as the machine's infected, I'm okay?
Well, okay. Now, we're dealing, though, with a criminal act. They don't really have the right to bitch about the fact that you are breaking the law when they've already broken the law. But we're in that gray zone now. You use those tools to grab stuff. You use those keys to grab stuff. It's technically a violation of 2511 and 1030. Whether or not you'll get indicted for it is TBD, to be determined. People are coming in. I'm getting out of here. I will happily answer questions outside. Thank you.
I had an incident in the late 90s where I had this moron from Arizona that predictably at 6 o'clock every night, Arizona time, was trying to break into the FTP server of mine.
Okay.
And I set up a cron job, started sending packets with his IP address, captured the data, and filed local police report and called the contact I had, the local FBI office, and